Several key labor laws have been enacted in the United States over the years. They amount to the National Labor Code. Let's take a look. 3 acts passed over a period of almost 25 years constitute the core of U.S. labor law: the Wagner Act, the Taft-Hartley Act, and the Landrum-GRIFFIN Act. The economic crisis of the early 1930s and the continuing restrictions on workers' abilities to organize into unions led to the passage of the landmark labor legislation, the Wagner Act, in 1935. Later acts reflected other pressures and issues that required legislative action. The National Labor Relations Act, more commonly referred to as the Wagner Act, is by anyone's standards pro-union. Passed in 1935, the Wagner Act was an outgrowth of the Great Depression. With employers having to close or cut back their business operations, workers were left with little job security. However, the high rate of unemployment and the large percentage of workers who were recent immigrants allowed companies to hold down wages and pay little heed to workers' concerns. Unions stepped in to provide a feeling of solidarity and strength for many workers. The Wagner Act declared, in effect, the official policy of the U.S. government was to encourage collective bargaining. Specifically, it established the right of workers to organize free from management interference. Workers were provided with the right to participate or not participate in union membership. The basic provisions of the law, spelled out in Section 7, protect employee rights as follows. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, to engage in other concerted activities for the purpose of collective bargaining or other mutual aid and protection. Employees shall also have the right to refrain from any or all such activities except to the extent that an agreement requires membership in a labor organization as a condition of employment. These Section 7 rights have broad application, in particular the right to engage in protected concerted activities, actions taken by employees working together to try to improve their pay and working conditions with or without a union. In addition to these rights, Section 8 of the law defined a number of actions that employers are legally prohibited from taking to prevent employees from unionizing. These are called unfair labor practices. Enforcement of the Wagner Act was assigned to the newly created National Labor Relations Board known as the NLRB, and today the NLRB administers all provisions of this and all subsequent other labor laws. The primary functions of the NLRB include conducting union representation elections, investigating complaints by employers or unions through its fact-finding process, issuing opinions on its findings, and processing violations in the courts. The 5 members of the NLRB are appointed by the President of the United States and confirmed by the U.S. Senate. The Labor Management Relations Act, better known as the Taft-Hartley Act, was passed in 1947 as a means to offset the pro-union Wagner Act by limiting union actions. It was considered to be pro-management and has become the second major labor law of the National Labor Code. The new law amended or qualified in some respect major provisions of the Wagner Act and established an entirely new code of conduct for unions. The Taft-Hartley Act confirmed employees' Section 7 rights and further protected them from restraint by unions. Several changes were made to the process of representation elections, most notably excluding supervisors from inclusion in the bargaining unit. Congress also added new types of elections. Of note, union members were given the right to hold elections to deauthorize or decertify the union, thus reversing the process of representation. The law allowed states to enact right-to-work laws and gave workers their freedom to reject union membership. A primary feature of the Taft-Hartley Act was the identification of unfair labor practices that might be committed by unions. Lawmakers recognized that companies may not be the only party that might violate workers' rights. The Act expanded the NLRB from 3 to 5 members and established the Federal Mediation and Conciliation Service, known as the FMCS, as an agency to help management and labor settle labor contract disputes. The Act required the FMCS be notified of disputes over contract renewals or modifications if they were not settled within 30 days after a designated date. The third major labor law in the United States, the Landrum-GRIFFIN Act, was passed in 1959 to protect the democratic rights of union members. The need for these members' protection grew from instances of corruption within the Teamsters and other unions. Some unethical union officials embezzled funds for their own use, basically stealing from their union members. Under the Landrum-GRIFFIN Act, unions are required by established bylaws to make financial reports and provide union members with a Bill of Rights. The law appointed the U.S. Secretary of Labor to act as a watchdog of union contracts. As required by the Landrum-GRIFFIN Act, unions must file a financial report detailing all receipts and disbursements of funds along with a breakdown of payments made for the following activities: representational activities, political activity and lobbying, contributions, gifts and grants, general overhead, and union administration. The National Labor Code provides for the foundation for understanding and managing within the context of organized labor.